and also call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled James Burke versus Nicholas Deml et al., case number 24 AP 369. Appellant James Burke is self-represented. Representing the appellee, Nicholas Deml, is Robert Menzel.
Thank you very much. Mr. Burke, you understand you have 5 minutes. Please go ahead.
Okay, it is an undisputed fact that appellant was arrested on the Vermont warrant on May 24th, 2005, and this is when his DOC time started. It is also an undisputed fact that appellant maxed out and discharged off of his 2003 misdemeanors in 2009. It is a further federal U.S. Supreme Court legal fact the maxed out and discharged off of misdemeanors are no longer valid and had no legal force to be counted again consecutive against a different and separate sentence that happened months later in this case. It is an additional undisputed fact that appellee respondent, Mr. Menzel, appellee respondent, admitted upon the public court record in open court at the October 8th, 2024 lower court bench trial that appellant had in January 2009 maxed out and discharged off of his misdemeanor cases. It is also an additional undisputed fact that several months later, long after appellant had maxed out and discharged from his 2003 misdemeanors in 2009, appellant was additionally sentenced to 18 to 20 years consecutive to 4 to 5 years on October 11th, 2012. It is also an undisputed fact that the Vermont DOC unlawfully resurrected appellant's maxed out and discharged from in 2009 misdemeanors and unlawfully added them cases onto appellant's 18 to 20 year sentence and consecutive sentence of 4 to 5 years sentence calculation. This violated U.S. Supreme Court's double jeopardy clause cases and also the Vermont Constitution. The Vermont Constitution has been clearly violated in this case. Appellees have clearly violated appellant's double jeopardy and Vermont Constitution rights when they unlawfully resurrected appellants maxed out and discharged from misdemeanor cases and then unlawfully counted them cases again consecutive against appellants different and separate sentence of 18 to 20 years and 4 to 5 years consecutive sentences that happened months, years later on October 11, 2012. The only consecutive sentence appellant received was the 18 to 20 years being run consecutive to the 4 to 5 year sentence. At the time, appellant received the consecutive sentences on October 11, 2012. He had long ago maxed out and discharged off the misdemeanor cases in January 2009. The Fifth Amendment double jeopardy violations in this case is because appellant is being twice put in jeopardy for misdemeanor sentences that he had maxed out and discharged from months prior to being convicted or sentenced on in unrelated felonies that he was originally extradited back to Vermont on. The reason why appellant was originally extradited back to Vermont on the felony cases is because the state of Washington does not extradite on misdemeanors, making the felony charges in this case the controlling cases. After the misdemeanor cases were resolved first and maxed out and discharged,
has 1 minute remaining.
They could not
You have 1 minute,
lawfully resurrected and used as consecutive sentences because appellant had already served his time on them misdemeanor sentences in this case. The Fifth Amendment against double jeopardy is designed to protect appellant against double sentence counting, as has unlawfully happened in this case. Again, the Vermont Constitution has been violated.
Mr. Chief
right.
Justice, this is Justice Cohen. Just for the record, I'm not participating on video, but I am participating on audio only.
Thank you very much. We'll hear from counsel for the appellee. Please identify yourself and your client and then proceed.
Thank you, Your Honor. Your Honors, good morning. Robert Menzel, Assistant Attorney General, appearing on behalf of Nicholas Deml in the Department of Corrections. I just want to reiterate that this matter was brought as a Rule 75 complaint for review of governmental action. To that extent, it was acting in the nature of a mandamus action in which Mr. Burke was alleging that the department abused its discretion in the way that it calculated his sentence calculation. There's a lot to unpack from what Mr. Burke said. We covered the double jeopardy issue, I think, in the brief. This is not a double jeopardy issue. This is not Mr. Burke being put twice in jeopardy for the same offenses. He had a sentence for the cases dockets 3, 0311, 03 CNCR, and several other cases. His case on the 3905 704 CNCR was a completely separate case, had completely separate facts, and was resolved subsequent to those cases. You know, there was a lot of evidence that went in before the court. It's undisputed that the department calculated the sentence using the amended minimus to the Commissioner of Corrections that was issued by the court. There was an error in the initial imposition of the sentence that the parties came back in before the court. The trial court actually reviewed the docket entries from that case and determined that Mr. Burke and agreed that the amended minimus would issue. That minimus indicated that the sentence would run consecutive. Just to be clear, the department doesn't impose sentence. The department doesn't create the minimus. The department makes its sentence calculations based on the documents that it received from the court. And the uncontested document that was the operative document in this was that amended minimus that was presented to the court. The court also heard from Kimberly Devins, who's the Defense Computation Unit Supervisor. He indicated that she had reviewed all the documents, and based on the documents that had been received by the court, received the policies of the department and the case law, the sentence had been correctly calculated. So our position is that this was a consecutive sentence that Mr. Burke is now unhappy with, but that does not trigger double jeopardy because they are two completely separate factual cases in terms of what the basis for the cases were. So it's not a double jeopardy issue. We would also notice that Mr. Burke has litigated most of these cases pretty extensively, and he had the opportunity on direct appeal to raise the issue of the amended minimus, and he failed to do so. And so that he tried to raise that issue. He appealed his case again in a PCR to the court, which was dismissed as being duplicative and barred by the doctrine of res judicata. And our suggestion would be that any attempt on his part at this point to go back and challenge the minimus would also be barred by the doctrine of res judicata because he already had the opportunity to raise that and failed to do so. And he's not really entitled to have a third bite at the apple at this point, having already unsuccessfully attempted to appeal other issues in the case. So based on the evidence that was before the court, we're asking that the department's sentencing calculation and the trial court's decision be affirmed. And I don't have any other issues to raise. If the court has any questions, I'm happy to answer them, but otherwise I would vote on the brief.
All right, I don't see any hands, so thank you very much. Does the appellant have time?
Yes, the appellant has 25 seconds remaining.
Mr. Burke, did you hear that? Mr.
It's an
Burke, you
undisputed
can-
fact that appellant was arrested May 24, 2005. And that's when his Vermont time started. And his max out for that is 2026, 2004, 2026. And any time over that is over his 22 year, he's litigating a 22 to 24 year minimum. Or he's got a 22 year minimum. He hits his minimum in 2026 on May 24th, 2005, or 2026, because he was arrested in 2005. The calculation, if you just calculate the 18 to 20 year sentence, it comes to that as his minimum.
All
As
right.
far as the misdemeanors go, they were maxed out and discharged from. And the fact that they were maxed out and discharged from, they've been resurrected and used again, which is double jeopardy. And the federal court, the federal law, and the U.S. Supreme Court law overrides all this lower court mistakes
All right.
pursuant to his calculation. And it appears that the federal court's going to have to sort through the federal case law that's been cited and decide that the calculation, figure out the calculation himself, because
Your time is expired, Mr. Burke. Thank you very much. Please call a conclusion.